with a bold decision. The decision to step out, take control, and build something of your own. Entrepreneurs are not made in comfort zones. They are made in moments of courage. Moments when you decide to move forward, lead, and grow. Welcome to ISFA, Indian Small Business and Franchise Association, the driving force behind India's thriving small business and franchise community. Since 2008, we have stood alongside India's MSMEs, enabling ideas to become enterprises and entrepreneurs to become leaders. Today, over 6.3 million MSMEs in India are growing, learning, and expanding with ISFA. With 1,200 plus live events every year and more than 1,500 industry enablers as partners, ISFA is a dynamic network of opportunity. We're shaping India's franchise future with fairness, transparency, and trust. At ISFA, we connect ambitious entrepreneurs to top global and Indian franchise brands. Whether you're starting out or scaling up, ISFA gives you the platform to grow. With funding support, skill-building programs, and international trade access, we help you unlock your potential. Small businesses don't stay small for long with ISFA. They become tomorrow's success stories. So, take the leap. Join ISFA today. Let's build the future of entrepreneurship together.
Good afternoon to all participants, industry colleagues, and member of ISFA. Gives me great pleasure to welcome you to this national webinar on new labor law code, the consolidation of multiple labor laws into 4 comprehensive codes, make a significant reform in India's regulatory framework. While these changes aims to simplify compliance and promote ease of doing business, they also require organizations to carefully realign their policies, systems, and compliance strategies. Today's session will focus on practical aspect of new labor law code, impact on employers and MSMEs, compliance and cost implications, practical do's and don'ts for HR and management teams. We are honored to have with us Mr. Rohitash Sinha, partner at King Stubb and Kashva, who brings extensive expertise in labor and employment laws. We are confident that his insights will help us better understand and practical implication of these reforms. I encourage all the participants to engage actively and make the most of this valuable session. Ask as many as question you have with you and you have facing in your company, in your HR system. Please ask from our expert. With that, I extend a warm welcome to everyone and invite our speaker to begin today's webinar. Over to you, Rohitash ji, and welcome to our ISFA portal. And we are very happy to have you today's webinar.
Thank you so much, Akshat. And good afternoon, everyone. Pardon me if there is a little bit of a lag because of my throat related issue, but nevertheless, Akshat, the paradigm shift, as you pointed out, has been brought about by the labor codes, and there are certain important provisions. There are certain important aspects, which need to be discussed, which need to be addressed. There are certain important positions that have been established. There are certain confusions that have been brought in by these codes. And there are also certain positions that we all need to establish or look into or consider from the point of view as to where this journey of the new labor codes will take us in terms of not only HR-related compliances, but also in relation to how we move forward in the in the coming future with regard to our employees, our workers, and all of these aspects. I'm sure a lot of the participants present over here would have attended, various conferences, various, webinars, would have read various articles, etc., with regard to, the new labor codes. So my endeavor basically is to, kind of look into all of these aspects, from a collective perspective, and kind of, try to show the exact mirror or the exact picture as to how things are moving forward, right? So before I move forward with regard to, the first code, I would like to point out as to what these codes basically relate to. Now these codes basically relate to a conglomeration of 48 main central acts, correct, that have been established or that were established from time to time, and that have taken into consideration the position of, various laws in relation to a payment of salary, in relation to how you, work it out in a factory, in relation to aspects of social security, in relation to aspects of employee healthcare. So what the position started off was in somewhere around in, when the new government came in 2014, was to liberalize all of these laws. And the process of liberalization actually took a lot of effort, because there was a lot of, a lot of pushback from the trade unions. There was a lot of pushback from certain employee section. However, there was a lot of, confidence or comprehension with the industry was giving, particularly the private sector industry, which basically stated that laws necessarily need to be liberalized. Correct. In this regard, what really happened was that over a period of times, these laws were enacted. They were brought into, they were drafts was suggested at various points of time. There were a lot of aspects in relation to various positions that were taken into considerations. The most common position which the government thought about was to bring about these acts, and the states would bring in their whole rules. However, when they saw that because of the pressure from the trade unions, of the pressure from certain employee-related groups, that they were not taking, any steps, the committees basically decided to, enact these laws per se, and have also issued the draft rules in this regard. Hence, what I also feel is why this session is important today is that you may have gone through a lot of sessions wherein you may have, you may have discussed various aspects in relation to the new labor codes vis-a-vis the act itself. But there are certain positions which have, acquired importance post the framing of the draft rules. The suggestion that the government has given is that they will become applicable from April 1st, 2026. Correct. That's what the, sorry, April 1st, 2025. That is what the suggestion is. However, it remains to be seen as to what provisions will become applicable, what provisions will not become applicable. Having said that, there is a very big perception that is going on in the industry right now that until unless the rules are not solidified or the rules are not notified, the act will not become applicable upon us. To this and to the dismay of certain people, what I would like to say is the acts are applicable as it is. Correct? Hence, all of those aspects, all of those positions that may have come to you with regard to, let's say, settlement of wages within 2 days, reworking of your wage structure, understanding the position of, let's say, certain classes of employees with workers, supervisory level, managerial level, certain important safety related aspects and safety related regulations, all of these have become applicable. Correct? So you need to take it into consideration that these are the provisions that are applicable. Having said that, let me first and foremost move to the most important position that has been taken into consideration is that of in the code of wages. And I think that is of prime importance to each and every sector. Not to state that the other laws are not important, but I think the code on wages has been the first and the foremost position that has been taken in as to what really needs to be done. Now, for 8 decades, the wage protection in India was governed by separate labor statutes. There was the Payment of Wages Act, there was the Minimum Wages Act, there was the Payment of Bonus Act, and there was an Equal Remuneration Act. Correct? Now, why a decisive step in the year 2019, and now once it has been enacted, what the government has done is it has kind of repealed, or it has kind of gone over and beyond the requirement to have 4 different acts. Hence, the archaic provisions of the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, and the Equal Remuneration Act have all now been combined into the Code on Wages. The primary aspect, as the code itself suggests, is the unification or the single codification of the definition of the aspect of wages, which is the most prominent aspect that is being discussed in the industry today. Hence, not only does the code on wages signify a change in terms of a single definition for wages, what it also does, or what it also provides, is unification in terms of as to whom this will apply on, unification in terms of as to what will be the legislative intent of the same, unification in terms of what registration, etc., really needs to be taken in this regard, and what the employers really need to do. Correct? As you may all remember, there were fragmented ceilings which are which are really present earlier, under which you needed to comply, or maybe you could have taken cover with regard to the fact that you weren't required to comply with the provisions of the certain acts. For example, the Minimum Wages Act primarily applied to only scheduled employment. The Payment of Bonus Act, which was a profit-linked or a kind of a revenue-based model, bonus, statutory bonus, that only applied to a category of employees or workers who earned 21,000 rupees or less. The Payment of Wages Act, as you would know, applied only to workers or employees who earn up to 24,000 rupees. And the Equal Remuneration Act was mostly a gender-based equality law, trying to cover the position with regard to the women employees, basically to state that in case they're doing similar nature of work as to men, then they will be entitled to similar salaries. Now, all of these have been taken away with a single definition of a wage. Correct? While we'll move on to the minimum wages and the payment of bonus and the equal remuneration, and the payment of wages separately, there has been a single definition of wages which has been granted. And we'll basically start from that position. First and foremost, I think, which is of very exclusive importance, is in terms of the definition of wages. And this applies irrespective of the kind of sector you are in. It applies irrespective to the kind of the position you are in, and it applies to all kinds of workers and employees. Correct? We'll move to the definition of workers and employees at a later stage, but first I'll explain to you as to what wages are. Correct? Now, under the new labor codes or the code of wages, the term wages includes, and this will be of prime importance to a lot of the people who deal with payments of salaries, your account system, taxation, and the HRs also, and those who deal with payroll. So now basically a single centralized definition, which and this definition, mind you, works across the board in terms of the minimum wage, in terms of the code of wages, in terms of the social security arrangements, in terms of your OSH, in terms of the IR code. It works universally. Now, primarily, this includes what we understand is your basic pay. Correct? So in a salary slip, if you take a corner on it, your basic pay is the primary basis on which your pay is decided, and all your other allowances and other aspects have been decided or are to be decided on, The next is, in the inclusion, is a DNS allowance, correct? So the DNS allowance basically takes into consideration the cost of living index, the cost of other indexes, the other aspects that are there, correct? And then we go into something which is called the retaining allowance, correct? Now, these primary form the core of your wages, correct? And as per the new code on wages, this has to be 50%, at least 50% of your total compensation structure or your wages, correct? Now, while these are the inclusions, what has been excluded is to take into consideration is your HRA, house rent allowance, that doesn't form a part of it, correct? The PF contributions, either from employer or employee perspective, will not form a part of the wages, correct? Or any accrued interest thereon. What also will not form a part is any sort of overtime that is paid or any sort of bonus that is paid, correct? Either contractual or statutory. What will also be excluded is commission, gratuity, and any form of retention compensation. Correct? So these are the primary inclusions and exclusions that are there in terms of the definitions of wages. Now, a lot of you may come with a position basically stating that, look, we pay over and above the minimum wage, correct? We pay, there is no requirement we pay equal pay to everyone, correct? And we also take into consideration that the wages are paid on time, etc. We take everything into consideration in this regard. Hence, why is there a requirement, or why is there or what is the liability that may arise upon us in case we are not restructuring our wages, or in case we are not looking into our wages from the point of view or from the aspect as has been provided herein. Now, what one needs to understand is the first and the foremost idea is that vis-a-vis, and I'll come to the 50% rule in the next slide, vis-a-vis the requirement, correct, of the payment of wages, which earlier primarily only applied to a particular category of employees or workers who earned up to 24,000 rupees, and which has now been taken away. There can definitely be demands or positions that need to be taken in, wherein an employee asks from you that his wages, which conform to the new definition of wages as per the code on wages, needs to be paid to him. Therefore, for those entities who are not following the newer structure, you may be entitled to claims by the employee, or by statutory authorities to stick to the new requirements to pay wages on time and in the manner as has been provided under the Code of Wages. Hence, your restructuring in this regard is very important. Also, why it becomes important to understand is as to whom these provisions are applicable upon. Correct? Now, these provisions with regard to wages are applicable on an employer. Correct? The code places a responsibility on the employer to take care of the provisions under the Act. With regard to an employee, correct? And the employee includes all form of employment, correct? Except for your your gig workers and platform workers, correct? And maybe consultants, because consultants are not considered to be employees, so those are not to be taken into consideration. And what it also does, or what it also provides, is that it applies across the board to establishments, irrespective of a number. So an establishment includes any place, and this is also very standard definition which has been taken across. It includes any place of work or any place where work is carried out either for profit or not for profit, and wherein there is a traditional employer-employee relationship or any other form of relationship, and includes the term contractor. Correct? So what the government has done is that in terms of an establishment, it includes the term a contractor also. So contractor will also be considered to be a employer, because in terms of an establishment, a contractor has been covered in terms of the position, and an employer entails the aspect of a establishment. Correct? With that, we come to, I think, to something which most of you are, kind of wanting to understand, or wanting to look into, or wanting to place your reliance upon a lot of things. Correct? Now, the first and the foremost thing that needs to be understood is, in terms of the inclusions, your inclusions should be basically correct. Your inclusion should be basically your basic pay, dearness, and retaining allowance. And they should form at least, or should be more than 50% of your total remuneration. Right? The reason for this is that the governments and the authorities have had a very tough, period trying to, uh, you know, take into consideration the wage splitting that has been put into provisions with regard to the wages. Correct? A lot of you may have, in terms of your salaries, a contributor which says what you are proving or providing towards gratuity. Correct? And from time to time, the governments have come across to state, or have the governments have come across a position to basically state that we do not want a splitting of the wages, so you pay a lesser social security in terms of PF, in terms of gratuity. We do not want that to happen. Correct? Or in case you want to exclude somebody from ESN. So the courts and the governments from time to time have come out with this position. However, to once and for all legislatively slot this position, the government came out with the fact, or the government basically has now put a 50% cap, or a greater than 50% cap, in terms of your salary, wages, as we may include. But what the government says in this regard is also something very interesting. Let's say you go a step further to interact, or you go a step further to look into all of these aspects with regard to what exactly are the positions that have been taken in with regard to the salary structuring. But you take the positions with regard to the exclusion still to be more than 50%. Correct? Then a sum total of those 50% will be added back to provide a greater than 50% requirement under the code for the definition of wages. Now, taking a colloquial example, before the code, let's say your remuneration was 10 lakh rupees, which was 60% allowances and 40% basics. Now, after the act, it'll change to, basically a wage of 60% basic plus DA, and 40% will be only considered to be allowances. Now, let's say you stick your neck around to the provision or the aspect to state that no, my allowances will still be 60% only. Correct? And I will continue on my base salary structure as it was without restructuring. Then the 60% which is being discussed over here, a 10% position would be added to the basic to make it 50% or greater than 50%. Correct? Now, what are these allowances and aspects which have been excluded, which may be included in case you do not follow the 50% requirement rule? As I said, it's bonus, conveyance, some pay to defray expenses, HRA, any remuneration or settlement or award payable, any overtime, commission, etc., gratuity that is payable, retrenchment compensation that is payable. So a sum total or parts of it may be added back to provide that 10%. Correct? Now, what are the major risks that are associated with all of these? The major risk that is associated with this position and which needs to be taken into consideration, or if it has not already been taken into consideration, is reworking of the wages by various finance departments, the HR, the payrolls, etc., having a software and software related entities comply with the requirements which have been provided under the code. As I basically pointed out earlier also, since the payment of wages does away with the requirement of any particular limit with regard to the payment of wages, each and every employee has the right to ask for wages in that particular manner as has been provided under the code. And if it is not being provided, you will be in violation of the same. Right? That I'll move to the next slide, and I will try and explain certain aspects which have been done away with. Correct? Now, as you all are aware, the Payment of Wages Act was earlier applicable only to employees who were earning up to rupees 24,000 a month, right? Those have been removed, and any protection with regard to wage payment now applies to such employees, correct? Irrespective of what they're earning. In terms of the minimum wages, it was restricted to scheduled employment, correct? Uh, and now it has been removed and it applies universally across the board to all classes of employees. There'll be no scheduled employment. How the minimum wage will be decided, I'll come on that later. But what the code does is it redefines applicability based on workforce classification by adopting the term employee. Correct. So these two aspects, while I'll cover in the IR code, I'll try and explain a little over here. The term employee and worker are a little traditional in nature as to what was to be understood as workman, non-workman. Correct. So worker now has, if not practically from a discussion level perspectives, being applied to what is understood to be a workman. And the IR code, which we'll discuss later, primarily protects the rights of a worker / workman, which has been done away with. And there is another definition in terms of an employee, which was not there in the previous acts, which now covers all classes, including managerial, administrative, and supervisory staff. Correct? So what you need to take into consideration or what you need to understand is that irrespective of if somebody is a manager, he's in supervisory staff, unless he doesn't form a part or is not a part of the management of the company, that means he's not an employer per se. Correct? There can be no position or there can be no aspect wherein you can, by that provisions, discard or not include certain employees under the provisions of the code on wages. The term worker is a broader concept and it includes the aspect of what we call as an employee. Correct? The code further goes ahead and adopts a sector neutral and internationally aligned approach to wage. Correct? So there are no sectoral caps or sectoral guidelines or any form of sectoral aspects wherein X, Y, Z can then state that in my particular industry, because of a particular nature, we will not apply this to us. In my particular industry, because of that particular nature, we will not apply this to us. Correct? You need to apply it sector agnostically to IT, ITS, retail, manufacturing, MSMEs, and even employees working in professional services. Correct? So tomorrow, if you have a lawyer who is working, say, in a professional, under a professional, let's say he's working under a doctor or a small MSME, etc., to state that I run a business which is a partnership or a sole proprietorship, and these acts or these codes won't apply on you. You need to take it into consideration that irrespective of this fact, irrespective of this position, the code will apply on you. And this is irrespective of a number or the number of employees that you are hiring or you have. So from 1 to 1,000 to 10,000 to a lakh, you need to have or you need to follow the requirements in terms of the code on wages. What you need to understand is that this framework of the code on wages aligns with the ILO standards, correct? And it also is, it's also something which is very much prevalent with regard to positions under the uh, jurisdictions like the United Kingdom, the United States, etc. This is what it kind of covers. Now, a lot of you may think as to why we are trying to draw the foreign jurisdiction aspect or why we are trying to provide this position to you. It is to provide a reasoning as to why the liberalization, or if you may call it the strictness, has come forth with regard to the code on wages. Correct? So this is what the universal applicability kinds of promotes. Now we come to the aspect with regard to gender neutrality. Correct? And earlier there was the Equal Remuneration Act, which required you to pay equal way from equal for equal remuneration, which prohibited discrimination in all forms and genders. However, now what we need to take into consideration is that you need to, irrespective of the gender, and this includes all forms of genders, men, women, or their physical capacity or incapacity, you basically need to take into consideration the position that all there can be no discrimination on the fact. Correct? And it applies universally without any position being taken into consideration unless there is a reasonable idea which has been provided as to why you cannot hire that particular employee. Right? Let's say for in a mining sector or in, let's say, in an industry or in a factory or a shop, you need somebody who is physically capable and you need a fitness certificate in that regard, and you're not able to handle despite that particular person providing his application, there can be no other reason which can be provided for the same. What also needs to be understood in this regard is just because the gender neutrality provision with regard to the code on wages has been brought about or has been kind of discussed over here, it nowhere takes away or it nowhere provides a position that the other acts or the other aspects which are there with regard to the disabilities and the assistances that you need to provide to the employees, that can be taken away. Correct? So that is with regard to the equal pay for equal work. What also needs to be understood is with regard to equal pay for equal work or gender neutral equal remuneration is the fact that apart from the inclusions which have been taken in the position of wages, correct? Apart from those inclusions that have been taken in, certain other aspects of exclusions only from the factor of calculation or calculating equal pay for equal work needs to be taken in for consideration of wages under equal pay for equal work. What are these exclusions? These exclusions are your conveyance and traveling allowance, your HRA, remuneration by way of award and settlement, and overtime. Correct? So only for the purposes of equal pay for equal work, you need to have to take this into consideration. If I may draw it with the term of an example, what you primarily need to do, or what you primarily need to take it into consideration, is the fact or the factor that that uh, in terms of, if you're not providing HRA to a woman employee, or to somebody of physical disability, or to somebody who is of a different gender, correct, then you cannot say, look, I have put a 50% cap over there and that is what is being taken into consideration. No, you'll have to take conveyance, HRA, and other aspects also into consideration. Then we come to the position that is there with regard to the final settlement. And this is very interesting as to how and what has been floating in the market right now. Correct? What has been floating in the market is that you need to make a full and final settlement of all of the aspects in relation to an employee upon his termination and resignation within 2 days, which includes gratuity, which includes full and final settlement, salary, which includes any bonus, which includes any contractual related aspects. Everything needs to be done within 2 days. The idea to be understood over here is that this is not to be done within 2 days. The only thing which needs to be paid is the final settlement is in terms of his wages. Correct? The only aspect that has been included is in terms of his wages. Those need to be paid within 2 days to a particular employee upon his exit or upon his position with regard to a position with regard to his resignation or termination for any other aspect other than misconduct. Correct? These provisions were already contained in the Payment of Wages Act. And certain shops and establishments like the Maharashtra Shops and Establishment Conditions of Service Act, wherein you were required to pay the wages fully within 2 days. Now this is being codified and you need to carry this out. However, what you need to understand is that your requirement is not to pay gratuity. Your requirement is not to pay any contractual or statutory bonus. A statutory bonus, of course, because payment of bonus would come under the provisions of the equal remuneration of the Code on Wages. Your requirement is not to pay any other aspect that has been decided except what has been included in terms of wages. Right. Then we come to the point, or then we come to the aspect of what we understand is the minimum wage. And this particularly becomes important for a lot of the MSMEs which are into manufacturing, or which are into distribution, or which are into the aspect of, let's say, any form of logistical services, where a lot of the wages or a lot of the workers are working, if not on a monthly basis, on a daily basis, and are hired through contractors. Correct? Now, the earlier minimum wage regime basically set out a requirement or a position which, took into consideration various factors, but did not define any, minimum floor wage. Correct? There was no applicability in terms of a minimum floor wage on the basis of which the minimum wages were decided. In fact, a lot of the work in this regard was being done by states very unscientifically, wherein there was no basis as to what needs to be decided and what needs to be done. Now, what has been decided under the Act is that there would be boards that will be set up, correct? And the central government will decide a minimum floor wage. Correct? When the central government will decide a minimum floor wage on the basis of the other factors, the center and the states, for various categories of work, not for scheduled employment, for various categories of work, will then, based upon skill level, cost, geography, correct, fix a minimum wage for each and every category, either state-wise or from a central perspective, right? As I basically pointed out, this will be for different categories of workers or employees, right? Hence, it will be universally applicable. Therefore, you cannot take out any sect or any part or any category of employee from the position or from the understanding of a minimum wage. Correct. Now, the criteria for discussing as to how minimum wage is decided is, basically on the basis of a spouse and two children, uh, a 2,700 calorie intake for the three of them, 66-meter cloth, fuel and electricity expenses amounting to 20%, expenditure on medical and other contingency of 25%, etc. Correct. So that is how you go about deciding about a minimum wage. In case you are trying to decide a minimum wage based upon a particular requirement or a particular position, uh, and if there is a monthly minimum wage that has been provided, or a weekly wage that has been provided, then you divide it by 8. And for a month, you divide it by 26. So the 4 non-working days have not been taken into consideration for, taking into consideration for deciding minimum wage. Now, there are certain issues which primarily have arisen with regard to the fact that, uh, what exactly does a minimum wage criteria entail? And now that the definition of particularly minimum wages and wages have been standardized across the board, how does it affect the employer? Now, let me bring it to your light that earlier, the definition of minimum wages contained a very principal aspect of what was called the HRA. Correct? Now, that position has been basically, done away with. That position of the, of that part has been done away with. And what you now have, or what you now basically have, a minimum wage, which will only primarily include your basic DA and retaining allowance, and on the basis of which it is being decided. Correct? So, particularly in terms of workers who have been employed through contract labor, employers may have to really review as to whether the compliances by contract labor are being done properly or not. If I may quote an example to you, let's say that the minimum wage for a particular skill or level, entry level requirement was 15,000. Correct? And that included the HRA, which was basically 13,000 and 2,000 rupees as the HRA. The contractor all throughout had been paying the minimum wage, including the HRA. Now, what may happen is that the contractor may, and as HRA will be excluded rather, pardon me for that, if the HRA will be excluded, the contractor will pay 15,000, which is the minimum wage which is required. Correct? And, or rather, he'll be paying 13,000 and 2,000 as the HRA. Correct? Let's say that's what the HRA was. So that brings down the minimum wage, because now the minimum wage ceiling is at 15,000. Correct? So that restructuring or that position also needs to be taken care of by the employers. You cannot have a position wherein you as an employer or a principal employer are being brought about to take into consideration such situations. Correct? Another factor that has arisen is, or which is being highly taken up by the trade unions, is the requirement of a national minimum floor wage. Correct? In fact, strange suggestions have been included in the requirements or in the positions which have been taken up, wherein the state of Kerala has, which has refused to apply the labor codes, is basically coming in with the provisions to state that we will have our own different floor wage. Correct. So this also becomes a very important factor to decide the minimum wage. And as has been suggested that, in case the DA and the other allowances, if they go up, you may have a higher minimum wage, and it may be a burden now for the employers to comply with the same. Hence, it is important to revisit your structures in terms of the minimum wage requirements as to what is being paid. And as we stand today, if it complies with the definition of wage as I provided to you at the start of the presentation. Correct? Then we come to the position with regard to as to what is the wage payment life cycle. Correct? So the wage payment life cycle basically, as was there earlier, has now been accumulated. You pay basically for, uh, you basically pay from the position of the wage period as daily, weekly, fortnightly, or monthly. Correct? That is what you are required to pay. Um Earlier, there was no provision in any of the acts to make any electronic or digital transfers. While most of the employers were making it, and they were put in the acts, but there was no provision for it, which now has been, there is a mandate. You can pay digitally also, correct? And your deductions and fines, that is there, cannot exceed 50% of the total wages. That was a position that was there also earlier also. And in case any deduction or any fine needs to be taken into consideration, that has to be, which is over and above the 50% requirement, that needs a prior approval of the government. The other entitlements that work about is the overall remunerations in terms of overtime. Now, in various places, the overtime extended, which was being given, was somewhere it was 1.5, somewhere it was 2, somewhere it was 1.5, somewhere it was just the same rate. So now there is a universal entitlement to overtime of twice the rate of wages. Correct? And what is also important to understand is that when you are paying any remuneration in kind, correct, it may be in, it may be in any form of, some form of, let's say, gifts or some form of any other form that is being paid and it is being made part of the wages, it cannot exceed 50% of the total wages. 15% of the total wages. Correct? So employers also need to, kind of take it into consideration as to what are the positions that will be taken into in case of that is being paid in kind. There is an extensive list which may be drawn upon by the government in terms of understanding as to what will be drawn upon in terms of understanding what is kind. But primarily it may be, in terms of a value of a laptop, in terms of value of any other perspectives that is being given as gift, etc. So those are the aspects, but it cannot exceed 15%. Then we come upon or we understand what we understand as a statutory bonus. And this is a very interesting situation as we stand currently. Now, the government has notified the act, but the government has within the act placed a position basically to state that the government may decide upon the position or the understanding as to whom the bonus will apply upon. There is no salary cap. There is no cap which has been provided as of current. Right? And how we take it as currently is in terms of the understanding under the General Clauses Act that we'll kind and the erstwhile rules to take it as the 24,000 aspect that has been provided under the Payment of Bonus Act. That is what we'll take it as it stands currently. Going further, there is the disqualification now also in terms of the Payment of Bonus Act, which apart from other aspects now includes any indictment under the Prevention of Sexual Harassment Act or any sexual harassment. Right. So any indictment under that can also take out your bonus under the Payment of Bonus Act. Now, this is where, and I think that's this is the most important position that needs to be taken into consideration. With regard to uh, what is the position on the record keeping, right? Now, the record keeping is the most essential part which has been done. While there is also requirement which will come under the OSH code to have employment contracts, what is important to understand is, you know, uh, that you can now maintain your registers and records in an electronic format. In terms of the code, there are only 2 to 3 registers that are there, which calculate attendance and the wages that are being paid. Correct. So I would request all the entities to go through those records and registers to see the particular format. You need to necessarily issue wage slips to the employees for the month for the period that he's been working for. So that is a necessary requirements. And at all times, you need to provide your notice of minimum wages, the working hours, and whatever fines, correct, that you're going to deduct at a conspicuous place in your premises. And now this conspicuous place can also be the intranet or the company website, etc. Correct. The earlier earlier requirements, as all of you may have gone through, a lot of legitimate and illegitimate requirements which had been put forth by various labor commissioners, saying that records have been not been maintained properly and have been not been maintained in a proper manner. I would request you to go through all of them and ask your particular teams and ask your particular departments and all of your providers, particularly in the payroll and the registers and necessary requirements, to now stick to the requirements that have been provided under the code on wages. Right. Now I come to a very important perspective, which I'm trying to provide, because out of all of these codes that are most important, while others might also be very important to the others, out of all of the codes which are very important, one needs to understand the enforcement mechanism that has been provided. Now, section 51 to 54 of the of the code provides for a facilitator come enforcement model. They have been not only provided with the power to impose penalties, they've also now been provided to the power to suggest certain mechanisms, etc., to rectify violations and to make suggestions also. Right? So there may be a power within an inspector to come tomorrow and tell you that, since you have, employees who are there on daily this thing, I would want you to maintain a register or record where they are signing upon the daily, wage being given to them and a minimum compliance requirement. Right? So now not only do they have the power to impose penalty or conduct inspection, they have the power to suggest changes also. What is also very important to understand is while there is a very good mechanism which has been established, which says that for the first time, if there is any suggestion given that is adopted, there will be no provision with regard to a penalty. Right? However, what you need to take into consideration is the enhanced penalties that have been provided. As to why we are, labor laws or labor compliance might not have really been of prime importance, because generally the or the labor inspection model used to go about a manner wherein the inspector was really not very serious about discussion or looking into the documentation per se, and neither were the employees. So now those and the fines and penalties were the same, usually ranged under different acts from 500 to 1,000 rupees. Now, in case of the inspectors now have the right to impose penalties of up to 50,000 rupees. Correct? And this may go up on the first offense on a repeat offense of 1 lakh rupees. What is also important to understand for all the audience present over here is that Earlier, let's say there was a problem or an issue which was facilitated, let's say, by you not having a policy of equal opportunity employment policy which had been displayed in your premises, correct? But now it has been done after it had been an offense and you now rectified and paid a penalty. So that was one offense. However, now if you look at this position, or if you take this position into consideration, any offense, let's say the one under the Equal Opportunity Employment Act, the other under a minimum wage, the other under, let's say, the payment of wages, let's say you did not pay the wages on time, that became one offense, which earlier or under the erstwhile act was only was the first offense under one act. Now under the now you did not pay the minimum wage, which is under the minimum wages only offense, first offense, but now becomes the second offense. And let's say you did not have a policy per se, which now becomes a third offense. Right? So now what actually happens, or what actually becomes procedurally to understand, is that you've committed three offenses, which may give rise to repeated offense and imprisonment also. The other position which needs to be understood, or which we need to understand, is that who can file claims, remedies, and who can adjudicate in this regard. So the claims can be filed either by employees, by the trade unions, they can be filed by inspectors or legal practitioners also. Now, if you remember, under the Erstwhile Act, there were a period of 6 months to a year that had been provided. Let's say, for example, under the payment of wages, it was a period of 1 year under which you could file your claim before the authority that had been established under the payment of wages. Correct? Now that limit has been extended in terms of what we call the Limitation Act to kind of correlate to that, and now that has been extended up to 3 years. Okay. Hence, it becomes very important to take into consideration that you need to maintain your records, your registers, any claims, etc., for at least up to 3 years. Correct. The adjudicating authority, which earlier you was only awarding penalties or etc. for the positions, can now award penalties up to 10 times the amount. Correct. And the reason for this is to kind of have a compliance related position in your entity per se, rather than being a non-compliant entity, for you to be a compliant entity per se. Now let us understand some of the important problems that have been there. As I basically pointed out, conflict between the national floor wage and the state autonomy to kind of fixing for the positions with regard to the minimum wage. We have seen the position that a lot of the states have taken into consideration. States like Kerala, others saying that we will not apply these laws. Particularly for the MSME structure, I completely understand. You have to now not only understand the 50% rule, maybe go back to your registers and records also, maybe look at the minimum wage requirement. But yes, primarily from a 50% perspective, I understand what the position is, right? Then we come to the major digital divide that runs in this country. While you may move forth for an electronic record presentation, will it move, or will it be in a position that will flow down to all the necessary MSMEs? There are a lot of MSMEs which may be coming from the rural sector. Has the position of 50% wages been transferred to them? Have they agreed to it? We don't know about it as of yet. If we look at a sector-specific impact, the ITES sector is the one which is taking the most impact. Correct. We already have companies like HCL, Infosys, TCS, who have kind of made one-time provisions in their fourth quarter with regard to what the changes that have been brought about in the definition of wages, particularly with regard to, if we look at the aspect of leave encashment, which flows from the position of wages. Correct. They, of course, will discuss this. The provisions of PF and gratuity, those also have affected them, and they have started making provisions with regard to them. Manufacturing and logistics face different but equally significant challenge. They rely on fragmented structures for payments, etc. Correct. They do not have that form of an electronic tracking, positioning, or systems. Correct. A lot of the positions that are established are done by the contractors, particularly in the manufacturing. And now, owing to the definition of wages and the 50% rule, there may be a higher payout in terms of your PF or gratuity, correct, and long-term statutory costs. So these are some of the important sector-specific economic factors that are going to affect you. What I would suggest in terms of changes is, one, start with the fragmented integration process, particularly look at your definition of wages, and which may not be pointed out by a lot of experts, is look at your records and registers very carefully. Correct. Float out all the aspects which are there in terms of your salary structures to employees in their agreement. Look at all the aspects vis-a-vis timely notifications that will be produced by the government, that will be put out by the government. For example, earlier there was a requirement that the definition of employee only included, or rather worker only included 15,000, which had now been increased to 18,000, right? And there has to be an understanding or a positional notion that needs to be accepted that these codes are right now applicable upon you. Correct? So these need to be particularly taken into consideration with regard to the code on wages. With that, I come to the end of my first presentation. Happy to entertain any questions for maybe, let's say, in the interest of time, for 5 minutes.
We have questions in Q&A box, sir, if you can see.
Yeah, I'll just hit that. So Nikita says, is 50% of total CTC, or it's 50, or is it on gross? Nikita, would be, if you're there over there, could you just point out as to what you are currently calculating it as? Correct. Current CTC. Okay, thank you. Now, this is a very interesting question, Nikita. Why? Because how you also calculate gross or how you also calculate net, it will become very important to take it into consideration with regard to that. What I would suggest is for you to go into the current structure as it stands in terms of the code of wages, to have the retaining allowance, DA, etc. At the moment, you should take it on your gross salary, in my view. Yes. I hope that answers it, Nikita. Right. Ambrish has asked that with mandatory contributions to social security schemes and gratuity provisions, how can MSMEs like us manage increased financial burden without affecting cash flow? Ambrish, very important question. What you need to understand, Ambrish, is that the statutory provisions of the ESI and the EPF still continue in the manner as they exist. There is the timeline of 1 year that has been given, which I'll also address in my position with regard to the code on wages. What you need to particularly understand, Amrish, is that you as an employer are allowed to restrict in terms of EPF your contribution up to rupees 15,000 and in ESI for 21,000. Correct? So those still exist at the moment as it stands. So you need not really take into consideration that point, that as to how it is going to increase the burden. The burden, if it may increase, as to what I'm really seeing upon, is in terms of gratuity. In my particular view, it's not going to be a position where the government is unilaterally going to apply provident fund and ESI irrespective of the salary, because then all of these aspects will go into a helter-skelter situation. So your position at the moment as it stands is that you can restrict your contribution, employer contribution to 15,000 under PF. And in case there is an employee earning more than 21,000, he can also do. Since the new code is of layoff and retrenchment requiring government approval. So I'll deal with the second part, Amrish, in the position when I deal with the IR code. But just to point out, it's a boon for you because it talks about 50, now it has been increased to 300. The 100 to aspect has been raised to 300 workers now. Correct. So all you need to do is take it into a position that you are basically following the law that is required in this position. Correct, which is basically providing them the retrenchment compensation, notice is being providing. I think the major factor which MSMEs really need to consider is that high and fire will not be some of the aspects. What system should be implemented for accurate record keeping and reporting under the new codes? Right. Now, the issues that have been brought about with regard to accurate record keeping have been provided under the Act. They have been done away with. Multiple registers have been done away with. You need to maintain only one register with regard to attendance, wages, and the salary that is being paid. What I would request is please have your positions on the parts to be taken into consideration in the form and the format that have been provided under the rules. Shubhra asks, what are the ambiguities that are being brought to light under the four labor codes, considering the rules are yet to be implemented? And how does it affect business on an immediate level? There are various ambiguities, Shubhra, that are brought to light under the four labor codes, which I'll also discuss in the other parts. One is, let's say, the requirements under the OSH codes, which points about a requirement of canteens and food to be provided to the contract labor. Now, contract labor across board is taken into consideration for various sectors. So, in case there is no manufacturing, will it still be taken into consideration? In terms of wages, as I just pointed out, you have done away with the position of the HRA. Now, that ambiguity really needs to a lot of positions under the contract labor as to how this will be kind of enforced. And if the contract labor doesn't, or the contractor doesn't pay, what will be the position? Another position which has been, there is a very big ambiguity is with regard to a lot of people who are, in the position or whose main salaries or wages generally account for or on account of, the kind of allowances and wages that have been brought forth to them. Correct? They may be in sales, they may be in delivery perspectives, they may be in other perspectives. So how does one address those, right? How does one, really take it into consideration? Another ambiguity which has been brought about, let's say, which we were discussing in the code of wages, is what has been excluded from the 50% is a settlement or an award with regard to remuneration. Correct. So now what is the position with regard to the erstwhile settlements that have been brought about? Let's say there has been a settlement between an employer and a trade union with regard to a higher wage or a particular wage structure. Correct. Now, because of the new labor codes that has been done away with, you will have to change things which have already been legally tethered and entered into. So now what's going to be the judicial position with regard to that? Correct. So these are some of the major ambiguities that have been brought forward. Going forward, I'll address the others also. Are the new labor codes applicable to university teachers? Yes, in terms of whether it's an establishment. As I pointed out, the establishment covers it. Yes. Any performance pay, though not scheduled bonus. Your performance pay will generally is also not included in terms of your in the ambit of wages unless it is given to you in your usual course of things. Akshat, could you just maybe point out, because I'm getting a lot of questions, could you just point out a couple of more which I need to address? And at the end of the session, maybe I can answer the rest.
Sure, we have two questions in our chat box because it's maybe we forgot to take it at the end. So one is from Atulya. Sir, in case employee work overtime in NFH holiday, how does it work 2x normal wages?
It's work from home, right?
Yeah, work from home.
It works on a similar basis as if he was working in a particular, uh, you know, uh, particular entity at that point of time. What also needs to be understood is that the state level Shops and Establishments Act have not been done away with. Correct. So any or all of the aspects of shops and establishment and the overtime contained in that will also parallelly apply. Correct. The courts have also been given very liberal interpretation to work from home, taking it that it should be akin to as if you're working. So the position that will work is, or how it will work is, that you need to be given a compensatory off for the position or for the fact that you worked on that particular holiday or leave.
Next question is from Mr. Vikas. His question is, any difference in liabilities will arise as principal employer and outsource manpower agencies and financial impacts?
I couldn't really understand as to what is the difference in liabilities that may come about. See, because your provisions with regard to the contract labor works on a basis of you paying him as per the agreement. Correct. There you're not making him pay, or you're not paying him in terms of the contract labor per se. If that would be the case, that might give rise to a structure of deemed employment. So I'm unable to understand that position. Yes, one liability which I just pointed out to you, which may arise, is in terms of the contractor not paying the minimum wage that is required in terms of the new definition. As I pointed out, let's say that it's 15,000 is the minimum wage, and he was paying 13,000 as minimum wage, and 2,000 as HRA, which HRA was a part of minimum wage. Correct. Now it will only be that it is 13,000 the minimum wage he's paying. 2,000 as HR is a separate one. So there will be a liability which the contract worker can claim from you.
The next question is the new labor laws applicable only to workers or also to other employees, staff,
As,
and
as, I,
managers?
as I pointed out at the very start of my slide, employers, employees, establishments, so it is applicable across board.
Sir, I think we should cover the rest part of the your presentation. Then we will take other remaining questions.
Sure. Thank you. Now we come to the really interesting aspect where everyone is kind of deciding upon to take it into consideration as to what is the IR code related aspect, right? The industrial relation code. Now, the industrial relation codes basically takes into consideration. My screen is visible.
No.
Yes.
Yes, now it's visible.
Yeah. Visible, right?
Yes.
Right. So the IR code basically, enacts the four.
Sorry to interrupt you, sir. It shows the folder, not PPT.
Correct?
Yes, now it's PPT.
Right. Thank you. So what we need to understand is the industrial relation codes, it consolidates some of the most important acts. And this is where we were discussing the concept of a worker and an employee that really needs to be taken into consideration. Uh, the IR code shifts from an old fragmented regime to a unified framework covering all sectors and modern form of work. The most notable position, which I think a lot of you have already been discussing, is the position with regard to the layoff and retrenchment provision, wherein 300 or 100, the provision with regard to layoff retrenchment as it contained, which was from a limit of 100, has now been changed to 300. Correct. But brings to light another important aspect is that of a fixed term worker. Right. So what we need to understand is that the law by itself, it simplifies and rationalizes a lot of the positions that were taken into consideration from different acts. If I may just quote an example to you, the Industrial Employment Standing Orders Act also contained aspect with regard to investigations. Companies also had their internal investigation mechanisms. The industrial dispute also contained as to how notice needs to be given. IESO also contained. So now they've combined everything into one. Correct. The other part, which is also very important to be taken into consideration, is the uniform definition of, as appointed, a worker across the board, strike and dispute. Right. A basic regulatory framework, attendance framework requirement, which changes from 100 workers to 300 workers. Correct. So what I bring about is the position that now, where there was a real irrationality which had legislatively also been perpetrated, because the Industrial Disputes Act, which was the main act which dealt with, which we were dealing with, as to who was a workman, who was a non-workman, whether a particular industry or whether a particular premise, basically fell under the Industrial Disputes Act or not. Correct. There were different provisions for manufacturing, for plantation, for railways. A standardized definition which used to come from some of the other sectors used to be that we do not have any workmen in our premises. Correct. So now what it has been done, or what the legislative intent has been, is to do away with everything and bring everyone into the position of a kind of understanding which is there with regard to all forms of employment or engagement. Correct. The first and the foremost in that is the traditional concept of a worker or workman, as we understood it to be earlier. And it basically contains an employee in an industrial establishment below a certain wage level, which is 18,000, in a non-managerial capacity, and includes sales promotion employees and journalists, and includes anyone of skilled, unskilled, kind of a capacity. Correct. Now, what is important to understand is there really a wide definition that has been changed to, kind of bring about in the IR code, which did not exist in the ID Act? In my particular view, that's not been the case. The only position that has been is that the wages have been extended or been exceeded to from 10,000 to 18,000 rupees a month. Further, as I already explained, the code expands the scope to an employer instead of referring it to an industry, and includes it in the terms of an establishment. As I said, it includes a contractor also. Correct. Further, the code also includes the aspect of an industrial disputes and continues to, look into the aspects of industrial disputes, etc. The other important aspect is a strike and a lockout, which is again contained, and it says a strike, can be only be done by 50 or more, at least the trade union or the union is giving at least a notice of minimum 14 days. Correct. Standing orders also stand as they are. Correct. The only thing that has been the position that has been changed, if you would notice, that the position has been changed from 100 to 300 workers. And the informal category of workers, or if I may call them not workers, but unorganized worker and platform and gig workers, they have now been defined for the first time. And they will be provided certain protection in terms of them joining and forming a trade union, in terms of any form of industrial dispute, strikes, layoff. They will also be provided certain statutory frameworks or requirements. uh, Now let us first establish as to what has changed, right? The first real position that has changed, and I will start from a descending order, is that in case you have 300 or more workers, correct, and you need to retrench workers in regard to that, only in those cases would you need permission for layoff, retrenchment, and closure. Correct. This number stood at 100, correct, and created major issues and fissures with regard to right to close a business, particularly for manufacturing units, wherein the governments, despite all of the factors, refused to grant permissions. Correct. Now, what has been done is the government has liberalized it to say that in case you have, let's change the number from 100, in case only have 300 workers, and in case of layoff, retrenchment, and closure, in case it's less than 300, you need not seek permission from the government. The other part, when we come to 100 plus more workers, is formation of a works committee, correct, with a joint management and worker body. Now, this works committee will then look at various aspects as to what needs to be carried out, what needs to be done, the basic benefits of a particular industrial establishment or an establishment. It will look into all of these factors. Correct. Then we come to something which the industry, particularly the non-manufacturing and non-logistical industry, is really trying to fight back, is called a grievance redressal committee. Correct. And it points out that in case you have 20 or more workers, correct, you need to form a grievance redressal committee. Now, this grievance redressal committee, has to be formed irrespective of the fact whether it provides any usefulness in terms of any orders or in terms of any, binding aspects. The GRC will contain members, equal employer and employee members. However, if you carefully note the provisions of the Act, they do not have any binding provisions. They're only suggestory in nature. And in case an employee or a worker is dissatisfied with the requirements or the suggestions, the suggestions of a GRC, the matter would be definitely referred to or can be referred to conciliation, statutory conciliation. Correct? So, why the industry is pushing back in this regard is because they're saying that at a very level, we are spending way too much time in trying to resolve disputes or trying to resolve any disputes which do not have any binding nature. And in the first case itself, it should be referred to the conciliation process itself, which has been formed under the Act. Last but not the least, any organization or any trade union which has any organization which has more than 7 members, they are free to form trade unions. It's the same threshold as before. And, trade unions can seek recognition from the government in terms of the previous Act, and that will be the position that will be, applicable upon them. Right? Now let's go on to the next one, which basically is, which we talked about, is in terms of the 100 and the 300 requirements. Correct. A lot of people ask me in the question box as to what is the position with regard to, how is it beneficial for an MSME? I think if anything, if nothing else, this is the most beneficial legislation that has come about with regard to an MSME. it liberalizes at a central level. While a lot of states had liberalized it at a central level, your provisions with regard to any aspect with regard to closure, layoff, retrenchment, once the number is less than 300. Correct? What you need to understand is that the most of the MSMEs which have a fewer number of employees, they will be freer in a position to just provide intimation to the government. Correct? There were significant bureaucratic hurdles when the number was 100. In fact, to be very honest, in our professional careers as lawyers, we have faced various situations where, despite the fact that factories and other units need to be shut down, because of strikes and because of lockouts from the workers, as they are traditionally called, they have been run and they have been run to the ground, thereby, creating a situation or a scenario of disenchantment to actually invest in India. And the ease of business then gets affected in this regard. Correct? Because one part, of course, is that you want to open businesses in India, but one part is also that you should have free closure within it. Correct? So this is where the provisions really, take into consideration the position that has been there. What needs to be taken into consideration is one very important liability that may arise with regard to the MSMEs and other entities is something called a worker reskilling fund. So basically, all retrenched employees, rather workers, correct? The employers are required to contribute 15 days last drawn wages to the fund for each retrenchment. Correct? So you need to do that once this fund comes into progress. This is a major liability that will arise on you, that on each retrenchment of a worker, you need to provide, positions which are there, and you will need to take into consideration those parts for providing a worker retrenchment fund, 15 days salary. This will be established, a board will be established in this regard, which will then look into how to reskill the workers, wherein they can then be employed or engaged in different industries. Correct? The other important aspect which you need to understand is with regard to layoff, retrenchment, and closure is that the provisions do not apply to any of the employees who have been hired on a fixed term. Correct? So the fixed term employees are not to be taken into position with regard to any aspect with regard to layoff and retrenchment. Correct? Some other important aspects, if I may just point out, are that the GRC necessarily has to have a women representative. Uh, there is a banned list of unfair labor practices, which includes intimidating, illegal strikes, etc. There has been a decriminalization of minor offenses. Correct? Many small offenses, like let's say there is a minor offense wherein you forgot to put the board, wherein you forgot to failure of having standing orders or to give notices, but you made the payments. This will not carry jail time, but will be compounded. Correct? As I primarily explained to you in terms of fixed term employment, fixed term employment comes out of the traditional concept of the IR code. So any worker who's on a fixed term employment also will not be considered to be a worker under the IR Act. Correct? However, what needs to be taken into consideration, which courts have regularly established, is that you cannot have this position from time to time to create a fixed term employment related requirement for regular employees. And two, you need to pay in case of termination for any reason other than misconduct before the period expires, before the period of contract expires, and the employer is the one who is terminating the employee, then you need to pay him for the remainder of the period because you had promised him in terms of a fixed term employment. As we all discuss, and in terms of the IR code, and which kinds of floats into the provisions of the Social Security Code. Gratuity. Gratuity now becomes applicable even to fixed-term employees who have worked for 1 year. However, what needs to be taken into consideration is that they will not be applicable, or it will not be applicable to those employees, correct, uh, who have, who are on fixed term or not on fixed term employment, but are terminated after a period of 1 year or 3 years, right? So gratuity as it stands remains for a period of, for regular employees who have completed a period of 5 years, but for fixed term employees, it arises in a period of 1 year. Right. Now we come to the aspect uh, of trade unions, correct? Now, trade unions and collective bargaining is something which is very necessary to understand, because in our considered view, this will not be restricted only to traditional manufacturing sectors. With the openness and liberalization, there is a possibility, and we have come across various sectors, including IT sector, where the IT trade unions, etc., have also been formed. Section 14 of the code creates a formal mechanism for identifying a sole negotiating union or negotiating council in an establishment, correct? So there may be various trade unions or negotiation related, or rather, trade unions or bargaining councils, but only the one which has more than 51% of the right, correct, or membership of the workers shall have the right or entitlement as a negotiating council, correct. If, let's say, one single negotiating council or trade union doesn't have the requirement or the process, then you can combine all of them to create a 51% requirement, correct? What is to be understood is that there can be a rejection from the part, or there can be a rejection to not negotiate with the trade union in or with regard to a particular requirement if that 51% requirement has not been put up, correct? So let's say there is a requirement and there is no support for a trade union. There are different trade unions and there's just one which represents 20%. They are representing it, correct? Then the position is that, they will not be entitled to, or they will not have the negotiating powers, correct? The second part is, what is to be understood is that 51% doesn't refer to workers on the roll. It refers to, rather, it refers to workers on the muster roll, but doesn't refer to only permanent employees. These workers can be engaged through contractors also. And as I pointed out, through the liberalized interpretation that is there, workers can be a part of trade unions also. Okay. As I pointed out, now you need to provide, or earlier also you needed to provide, which has been retained, is that you need to give a mandatory notice of 14 days. No strike during conciliation or arbitration for 16 days after the procedure concludes. Now, if, let's say, more than 50% of the workforce goes on leave, that will, on mass casual leave, that will also be considered as strike, and you will need to provide a notice for that also. This is where the position has now become really interesting, is that earlier illegal strikes, etc., did not extract too much fine under the ID Act or the Trade Unions Act. Now these fines can be up to 10 lakh rupees. And any financial support for illegal strikes is, prohibited in this regard. Right? Let me just rush through a little bit of the requirements under the other positions. Is that any employer who has the requirements of a grievance of 20 or more employees needs to form a GRC. As I said, there has to be more than 1/3 has to be women, and the resolution has to be provided within 30 days. But this resolution is not binding. Standing orders, again, a kind of a liberalization, which basically talks about employees, or rather 300 plus workers. Only then, there'll be standing orders for particular classification or class of workers. correct? So basically, your small and medium enterprises, which is actually good news for you, 50 to 299 workers, you do not need any certified standing orders in that regard. Uh, Now, under the old system, the control was basically via unions, the government on with regard to job losses. Now, the court moves toward decision making or a decision related aspects into legal frameworks and compliance related systems. Correct. Um, you need to have definitive contracts. There is a GRC, and if the GRC fails, then you go into the related particular system with regard to that. While earlier on any normal related dispute, also an ID dispute could have been created and could have been formulated before the conciliation officer. The impact, of course, the impact is very, very liberalized, as I talked about. Easy restructuring, the 100 worker rule is out. You need only to negotiate and only to bargain with those which are 51% requirement, correct? Stricter enforcement on larger firms, like fines for Maharashtra and TN for closure notice violations. You need to follow the 51% norm, as I basically pointed out, and trade unions cannot throw their arms around to have your units closed. What is important is the other factors that have to be taken into consideration, which are the most important ones. First, and the most important, is in terms of night shifts which have been recognized. Now, either these concepts were already recognized in terms of the positions that were there on the IT and BPO sector, or they were kind of somewhere down the lines policy wise included under the shops and establishment, but never really followed. The IR Act completely provides that you need formal procedures, and women are allowed in night shifts only from a perspective if they provide their approval on the same. Correct? So you cannot force a woman to work in a night shift in case she doesn't accede to it. Only if a woman accedes to the provision will she be allowed to work in a night shift. Right. As I pointed out, the shift is from imprisonment to financial penalties. They can be compounding, greater flexibility in terms of strikes and lockouts, in terms of higher fines. So the trade unions and the workers would be more less inclined to go on a strike. Strike notice under the old law only for public utility, right? Now you need to give it for all sectors. 100 workers, union recognition is a 51% rule. Standing orders for 300. One little financial liability in terms of the mandatory reskilling fund. And now fixed term employment, which is not really contained, is fully legalized. Right. So with that, I come to the end of my second aspect on the IR code. Akshat, I'll just quickly cover, I think, the code on social security. Correct. I may not find the appropriate time to really clamor into the OSH code, but I'll cover the code on social security because that's the most important one.
Okay. So we should take the question post that.
Yeah, we'll take the questions post that because I think there is a little bit of paucity of time. So I want to cover that.
Sure. Okay.
My presentation is visible, right?
Yes.
Right. Now let's come to what we generally understand or what we generally relate to is in the code of social security. Correct? And what it does away with or plans to do away with is the Employees State Insurance Act, the EPF, the Employment Exchange, the maternity benefit, gratuity, and certain other funds that were created primarily for certain sector specific related requirements, which then tells us again a very important aspect with regard to the Code on Social Security, which is to suggest that it will be applicable to everyone, irrespective of the nature of their employment, irrespective of whether they're a worker or an employee. To go a step further, it may also be applicable and definitely will be applicable to gig and platform workers. Correct? Now, what needs to be understood is that the code has significantly in terms of certain changes, particularly for fixed term employees, and with regard to how it will become applicable on the other kind of workers. It is significantly brought in a paradigm shift in terms of the of how social security will be taken into consideration in India. Correct. When we talk about the social security code in India, it again, as I pointed out, takes into the definition not a worker but an employee. Correct. The employer includes any form of service and contractors. Correct. And it includes fixed term employees also. So any of your employees who are on fixed term and fall under the statutory requirements as maybe the position in the social security code, they will also have to be paid or have to be provided with social security as has been provided, which primarily includes provident fund, ESI, gratuity, and the benefit of maternity. Now we come to the important aspect of the gig economy, correct? And the aspect of a gig worker, right? Please try and understand that the position before the code on social security for app-based workers was very scattered. They were regulatory, not really aligned on any of the benefits that were to be provided. Certain states provided certain benefits, certain entities which provided benefits to them had certain insurances, but they were really scattered. Correct. Now what is being done is, in terms of this code and the IR code, the government is saying, A, you need to register the workers. You need to register the gig workers. Correct. And who are basically gig workers? Gig workers are those who perform work outside traditional employer-employee relationship. Correct? These gig workers need to be registered by aggregators. And who are aggregators? Aggregators are those who, for any point of time or any aspect, utilize the services of a gig worker. Right? The position basically is also very similar for platform workers. Correct? Platform workers are very similar to what gig workers do. And they are basically people who provide certain services through platforms. Now, these are your urban companies of the world. These are your certain, other app-related based services of the world. Correct? And these gig workers and platform workers are provided now an umbrella through the government, through an aggregator. And what is the prime importance for it? The prime importance for it too is to extend social security to them in terms of PF, ESI, maternity, etc. However, there is a large vacuum or a large position that still exists in this regard. Correct? One is in terms of as to how do you decide that a particular gig worker is entitled to certain amount of social security. How do you regulate the number of working hours in terms of a gig worker? Correct. Now, if you start providing social security to a gig worker vis-a-vis an aggregator and he starts working for him, and we are all still grappling with the position under the contract labor provisions, correct? The core activity, the non-core activity, all of these, we're still grappling with it from a very large perspective. Won't this give rise, which is already there, and we are dealing with a lot of matters related to that, won't this give rise to the gig workers and the platform workers filing cases or asking for regularization as employees? Has there been an exclusion that has been created? Not to my knowledge, not to my particular view. Correct. So these are some of the important aspects that need to be adhered to and which governments and the employers really need to take it into consideration, particularly you as MSMEs need to take into consideration. There will be a board that will be established which will decide upon the kind of benefits that will be extended to gig workers. But what needs to be taken into consideration is something which you can do right now is to have provisions within your agreement to not to include them in a traditional employer-employee relationship. Correct. In as far as possible, at least on your portals, wherever possible, start registering them so that and have a separate position with regard to gig workers. Develop a separate policy, a policy document for gig and platform workers, which at no place entails any of the provisions that are which a normal employee would be entitled to. So please start drafting those policies. One mistake which a lot of the current employees do is that the insurance policies that they take out for the benefit of the gig workers is the one which is an extension of the employee's insurance policy also. And I would really, really recommend that you need to keep these people out from those provisions, have a separate policy. Correct? It may be compliance, it may be a statutory cost, but overall you may save a little bit of a burden in that regard. Right? Now, what has been predicted or what may be the consideration is that gig and platform workers will be entitled to some statutory social security fund, correct? It will be capped at 5% of the total payments that will be made to workers over a period of year annually, correct? One process which has already started is that their Aadhaar linked aspects are being captured on the eShram portal, and the government is in the process of formulation of a fund. So these are some of the very important aspects that are being, kind of taken into consideration in this regard. As we move forward, and which I basically did, was, to have the platform model as a separate model post the implication of the codes which have already come in. Correct? Have a separate policy for your gig and gig workers and platform workers. Avoid any form of CSR or CSR related applicability on them, which may entail any form of, knowledge or any form of entitlement where they may say that the company is contributing funds to us. Correct? And, continue the coverage via portability mechanism, which has been formed by the government, while having exclusive clauses within your contracts and within your policies to state that they will not be considered to be employees. One of the important aspects that has been provided and which will be applicable on the code on wages is that you now have one particular requirement for registration All employees, aggregators, and workers will be registered on one portal. You will have to submit quarterly returns in this regard. And in fact, the position that has now been taken is that you may also not have to submit returns. They will be easily available for review by the particular authorities. Correct? And the inspector cum facilitator, he's on a dual role, as I pointed out. He can conduct a risk inspection. He can tell you in this regard, as I pointed out, that these positions may create a situation where the gig workers may be recognized as employees, or you need to particularly provide a particular kind of enforcement aspect with regard to the same. Now, basically, this is what currently runs in terms of, the EPF and the ESI and the other ones which I'll explain to you, right? And in terms of the Act as we stand across, in terms of EPF, ESI, and gratuity, until unless the schemes have not been formed, for which a period of 1 year has been provided, that is by April 2026, they will run as it is, even though the Act and the notifications provide that they have been, kind of done away with. EPF will run irrespective of the number of employees once it comes into position. Gratuity, as we pointed out, will run irrespective of the number of years for fixed term employees. Maternity, which I'll discuss, for 2 minutes after this, will now provide not only coverage in terms of maternity benefit of 26 weeks and creche for 50 or more employees, but a provision with regard to shared creche services for, ease of convenience, etc. Right? You will be covered. There will be a larger coverage of the Employees Compensation Act in terms of what may be covered through accidents. Correct? And as I already discussed, that the gig and platform workers will have to be registered in this regard. I'll come to the most important aspect to understand as to what it is, because we're a little bit short on time on that regard.
Sir, I think we should start the questions first because we have too many questions.
Okay.
We will share the presentation with the participant. If they have required any detail, they can reach out to you.
Sure.
So please take a question from Q&A box first.
Right. Yes, Dhirendra. The applicability starts from the month or this thing of November 21st. So that is exactly how you will take it, that you will divide before 21st and after 21st, since the law has become applicable. What I would suggest is there may be a kind of certain clarification which may be provided, but we'll have to look at it. Leave encashment is on basic salary, which means wages. Yes, absolutely right, Venkat. It's on the basis of the new salary, but what needs to be taken into consideration or what needs to be understood is that your shops and establishment has not been done away with. And in case there is a better provision for leave encashment under the shops and establishment, state shops and establishment, then that will prevail over the leave encashment that has been provided under the new codes. Again, the flexi reimbursements in terms of fuel, vehicle expenses, books and periodicals would be taken into consideration for PF calculation and wage calculation if they are given in terms of a wage. Correct? If they are not given in terms of a wage, it will not be considered. I think that would... Yeah, go ahead, Akshat. You wanted to answer that.
Okay. So next is Mr. Rakeshan, Mr. Venkateshan. Could you explain how the new 50% rule prevent artificial wages splitting?
Correct. I'll just explain to you. So let's say your basic DA and retaining allowance was, how you basically, and particularly let's say for a PF example, you had a salary of somebody who, let's say, was on, let's say, for 10,000 or 13,000 rupees a month. And you basically split that allowance to state that my wage which I'm be paying on in terms of the provident fund and the definition of wages as per earlier provident fund, I would only and only pay it on the basic and the dearness allowance, not include the HRA. I would split it into different wages, saying a kind of a, let's say, attendance allowance. I will shift it into an overtime allowance, etc. Correct? I will pay it into a kind of a retaining bonus. This is how I would split the wages earlier. Correct? And then what I would say is that instead of the 14,000 component which on which provident fund was required to be paid, I would, let's say, that my basic salary was only 8,000 and 6,000 was all split into different kind of wages. So what I would do is, or what I would take into consideration is that I have to pay provident fund only on 8,000 rupees. Now to
So
do
we have
that,
to, sorry to interrupt you. We have 2-3 minutes with us because we have next session also at 3.
sure.
So if you can answer in a very precise manner, and I request all the participants, those have the query, we will share the presentation and the contact detail of the speaker. You can reach out to them directly. You can post your query through email to them, and his team will reach out to you for the answer.
Right. I'll
So we
answer.
will ask you 2-3 questions in for that. The next question is from Mr. Sanjay side. Is the new labor law applicable to workers or the staff or employee also?
It's applicable to the staff and employees also.
Okay. Next is we are into HR services business providing third party payroll in industry. What permission or license are compulsory?
I think this will be not a part of things in terms of their licenses, but generally what may be required is if they have more than 20 employees, PF registration, ESI, etc. And in terms of the new code, while no particular registrations have not been prescribed, but they will be prescribed for the Social Security Code and the USH code. So we'll cover that.
Okay, so next is, sir, in case if employee do done strike, like remuneration need to be paid or no work, no pay.
That comes in the provisions of an illegal strike, correct? You will have to look into the provision of the IR code with regard to that. You can only deduct a particular amount of wages even for that. And then you may look for particular disciplinary action against that employee. So as I said, only 50% of the wages can be deducted. And if it continues, then you can go in for disciplinary action.
Okay, thank you very much to all the participants. Sorry, we are not taking up all your queries due to paucity of the time. But I request all of you, please drop an email of your queries with us or the speaker when you are receiving the contact detail from our side. And we will definitely answer all your queries. Thank you. Thank you very much for joining us today. And we have our next session on how to choose a right franchisee and invest in the right franchisee on 17th of February at 4 to 5 p.m. Please stay tuned with us and join us on the same day. Thank you, sir, for your expertise. And we will arrange the next session on the same topic because we have a lots of query and interest of our members.
Sure.
And look forward to your support, sir.
We'll cover the USH code there.